It's no surprise that people in all walks of life have scrambled to keep up with changes brought about by the COVID-19 pandemic, and that includes trial lawyers. Our next guest recently warned readers of the Washington Examiner about a potential negative outcome as the nation recovers from the pandemic. His article carried the headline, "Saving the Recovery from the Trial Lawyers." The author of that piece is James Copland, Senior Fellow and Director of Legal Policy at the Manhattan Institute. Welcome to HeadLocke.
Thanks for having me, Mitch.
So first of all, we should probably clarify, I am not an attorney. You are an attorney, but you'd like to save this recovery from some of your colleagues beyond the bar.
Yeah, well, I like to say I'm not a real attorney. I just play one on TV. But I did go to law school and have been doing legal policy work for almost 2 decades now. So something I spend a lot of time thinking about and talking about. And it's important to realize the lawsuits are coming. And that's what we've got to think about. Every lawsuit is not the same. Some lawsuits are important, some are necessary, but we need to worry because the lawsuits might affect our public health adversely in a time of pandemic, and they also might adversely impede our recovery. And so we've got to get this right, and our policy members need to think about it. But they're coming. When I wrote my piece, there were well over 2,200 lawsuits related to COVID that had already been filed, and that's already data that's about a week old now. So I imagine that's grown substantially even since then, and we need to be thinking about what that means and what the policy responses need to be to ward off the negative effects of bad lawsuits.
At the very beginning of your piece, you remind us of a sort of semi-famous quip now, the one from the former White House Chief of Staff and Chicago Mayor Rahm Emanuel, saying that you never want a serious crisis to go to waste. And it seems as if a lot of people are looking at the COVID-19 pandemic as a way to try to get something they really wanted otherwise, regardless of the health problems.
Yeah, I think that's true. And I think that's an important cautionary note for Republicans or for legal reformers who want tort reform or want liability reform. I am among that group of pro-liability reform public policy folks and scholars. That said, I think it's irresponsible to try to leverage the crisis to fix tort reform. And I think, quite frankly, very much unlikely. Certainly that's true in Washington, D.C., where you've got 2 different parties in charge of each house. And it's true as well in North Carolina, where you've got, although one party in charge of both houses of the General Assembly, you've got someone of a different party in the governor's mansion. So I think it's important to be responsible in the way we think about it and to tailor relatively narrowly our response to the actual imminent crisis that we're facing, which is a level of economic dislocation we haven't seen since the Depression, and a viral pandemic of the sorts we haven't seen in more than 100 years. The combination of these 2 things leave us in an unusual situation, and we ought to tailor our policy response to that situation.
You also warned fairly early on in this piece that a group that works with trial lawyers, one of their national groups, has already been busy setting up websites to help people who are trying to file lawsuits connected to COVID-19. Tell us about that.
Yeah, this is what's now called the American Association for Justice, which sounds a little bit about like the DC Comics Justice League of America or something, but it's really the trial lawyers group. They used to call themselves the American Trial Lawyer Association or the Association of Trial Lawyers of America. They had both those terms. Why they switched those, I don't know. But they decided we're going to drop the trial lawyer word entirely and just say that we're for justice. And so they're the principal lobbying group, the principal political action committee for the plaintiffs' bar in Washington. And they also help to give their members ideas about trends, including litigation trends, and sort of serve as a clearinghouse for this. So they've already set up a website. And that website's designed in part to help prepare COVID-related lawsuits against businesses. They title it covid19.justice.org. So I guess if you're a plaintiff's lawyer listening, you can go there and get ideas for prospective lawsuits. My concern is a lot of these lawsuits are going to be unwarranted, very costly, and compromise public health and economic recovery alike.
You point out that in terms of the federal government and Washington, D.C.'s response to this, battle lines are already drawn, that early on there was this attempt to protect some people from some of these lawsuits that would come about, but that spirit of bipartisan cooperation and bipartisan interest in protecting people from this raft of lawsuits has dissipated.
Yeah, I mean, the early moves, and there have been a number, the CARES Act is the big one everyone hears about, but there are a number of predecessor bills in the Congress that were enacted with bipartisan support very early on in the pandemic. In March, we had a number of these, one of which extended liability protections to the manufacturers of respirators, these sort of masks, the hospital masks, not just the sort of surgical masks, but the N95 masks, these specialized masks were not covered by what's called the PrEP Act. And so the PrEP Act is the 2005 act that Congress enacted principally in the wake of the 9/11 terror attack. PrEP stands for Public Readiness and Emergency Preparedness. So the PrEP Act in 2005 really gives broad liability protections to folks trying to respond either to a pandemic or a terror attack, including the manufacturers of medical devices, of pharmaceuticals, of vaccines, of testing equipment, things that come under the purview of the Federal Food and Drug Administration, the FDA. But the masks weren't FDA, they were regulated by another part of the government. And so the bipartisan bill in March brought those masks under that sort of broad product liability immunity that Congress has already set up for many of these sorts of classes of cases. But there are lots of other conceivable things out there that don't really fit within the FDA that could be subjected to significant tort litigation. And while there is broader protection on the books since 2002 in Washington for responses to a terror attack, it doesn't extend to the sort of natural biological epidemic that we're facing now. And so that's one reason a lot of us think Congress needs to think about those sorts of issues.
But at this point, it doesn't seem as if there is a lot of cooperation in Congress to do that.
Yeah, exactly. So the initial movement in March was bipartisan. Since then, while Mitch McConnell has emphasized he wants broader liability protections to be part of the response the next time around, while the White House has signaled that, Nancy Pelosi, the Speaker of the House, a Democrat, a member of the other party, and Chuck Schumer, the minority leader for the Democrats in the Senate, have said no way. And they basically said no way because the American Association for Justice, the plaintiffs' bar, has themselves said no way, along with a lot of folks advocating on behalf of the plaintiffs' lawyers, and they have a lot of sway. The American Association for Justice Political Action Committee is the third biggest donor for Democrats running for federal office. It's only behind a couple labor unions. It's concentrated. 97% of their money goes to Democrats at the federal level. It's consistent. $5 million a year or more have gone to the Democrats in every 2-year political cycle dating back to the mid-90s. And beyond just the Political Action Committee dollar figures, you get a lot of bundled cash because our campaign finance regime at the federal level makes it incumbent upon individuals running for office, unless they're wealthy enough to self-fund, to raise money in small doses of 4,000 some odd at a pop in a political campaign, which means the ability to bundle individual contributions is crucial. And that's what the plaintiffs' bar has really excelled in. So they've done this quite strategically. So Dick Durbin in the Senate from Illinois, a Democrat, is the the minority whip, the number 2 person in the Senate, in charge of whipping votes together on pieces of legislation. And 4 of his top 5 donors are law firms, 3 of which are personal injury asbestos law firms. They're able to really utilize that giving and have Durbin make sure that the caucus follows along. They do the same thing in the House. So the majority whip in the House, the number 3 person there, is Jim Clyburn of South Carolina. Everyone knows him who followed politics because of his influence on the Democratic presidential race in South Carolina. And the law firm Motley Rice, which is one of the big longtime asbestos firms, one of the big architect firms of the tobacco lawsuits that entered into a multi-billion-dollar multi-settlement agreement with the states. They're one of his 3 largest donors and his 2nd biggest, excluding a general PAC. So the trial lawyers have a lot of clout in Washington, and they're basically saying, no more, you got your masks, and that's enough.
Some people might hear us and say, well, wait a minute. We really don't want people to take advantage of those who are in a pandemic and give them some either services or goods that are defective, and they should be able to sue if they get something that doesn't work. Why? What is the proper balance between protecting the people from those bad actors and protecting the companies from lawsuits that would cause all kinds of problems that are bigger problems than the problems created by their products?
Yeah, I mean, it's an important question, and it's important to realize that when Congress, in times of more relative calm, when they enacted the PrEP Act, it was 2005, they've thought through some of these things. So first of all, the PrEP Act, as I said, really applies mostly to the sorts of products that are in the Food and Drug Administration's orbit. Well, those of us who follow the Food and Drug Administration, it's another piece of the puzzle that I look at in my work, realize that they're, if anything, overly cautious in letting things through. And we saw that in this very crisis when the Food and Drug Act granted what's called an emergency use authorization for testing for the novel coronavirus. Obviously, there was no prior approval for a novel virus's test. It hadn't gone through any sort of testing because it was brand new. But they granted the only emergency use authorization to the Centers for Disease Control, their sister federal alphabet soup agency. And we saw what happened. They only made about 5,000 tests. The first batch of tests didn't even work. So where South Korea was getting lots of tests out there, we really had a completely failed testing process. And they didn't let a private sector company, Roche, in on the game until March 12th. By then it was too late. So the bias of these agencies is toward not letting things through, and yet they still have to do it in a lot of cases. So if they grant an emergency use authorization, or certainly a drug that's already been through FDA review for safety and efficacy, the public risk is somewhat muted. It doesn't mean there's no public risk. And Congress, in fact, accounted for that. So there's actually a compensation fund through the PrEP Act that allows individuals compensation if there's an injury and it goes through the process to be compensated. We do that for vaccines. Vaccines are really important in fighting a novel virus, but the trial lawyers almost wiped the vaccine industry of the United States out by the mid-'80s, which is when Congress created what's called the Vaccine Injury Compensation Program that allows parents and children who suffer a childhood vaccine's side effects, and they happen in rare occasions, to get some sort of compensation without the trial lawyers jumping in and effectively killing the industry that's vital to the public health. So it's an important sort of trade-off. The PrEP Act exempts willful misconduct. So if there's someone intentionally trying to defraud you, they wouldn't be exempted from liability suits. And realize that these alphabet soup of federal agencies, as well as their comparable enforcement bureaucracies at the state level, still have enforcement powers here. We're really just trying to take out of the picture this sort of ex post enforcement power through litigation that enables shakedowns. And we enable shakedowns in part because you win your lawsuit as a defendant, you don't get your fees paid back that you paid to your lawyers the way all the other developed countries, all the European countries structure it the opposite way, so that which deters the sort of shakedown lawsuits we see in the United States. Here, that's not the case. And so it tends to be a quite inefficient way to regulate, because for every good lawsuit, you also get bad lawsuits that are really shakedowns.
You mentioned states, and as we wrap up, I wanted to talk to you about if there's any action that can be taken at the state level in a place like North Carolina, because we have focused a lot of attention on the federal government and Congress. But are there things in terms of product liability that North Carolina's General Assembly ought to be considering?
I would say North Carolina's General Assembly's already been out in front of the curve on this. They passed legislation that I flagged in my report in the Examiner. I flagged in my long form essay. It's called Senate Bill 704 that was enacted by the General Assembly that created various liability shields, particularly geared towards the healthcare sector. But even North Carolina even went a little further. Even places like New York and New Jersey came up with healthcare sector shields, and North Carolina went a little further, basically saying that if a business qualified as an essential business, as defined under the governor's orders for regulating who could and couldn't be open during the pandemic, well, as long as that emergency order was in place, those essential businesses also had liability protection. So North Carolina's done a lot. Our liability system, when it comes to product liability, is an inverted form of federalism. So a North Carolina company, even if the General Assembly comes out and comes out with a new product liability rule, they're still going to be subject to potential lawsuits in the other 49 states, which means North Carolina producers are unfortunately going to be subjected to prospective litigation that may be harmful absent federal action, and that's why federal action is a piece of this puzzle. But I want to applaud the North Carolina General Assembly and the folks at the Locke Foundation who helped guide them for moving aggressively and quickly on this and doing it in a fairly comprehensive way that went beyond what we saw in a lot of other states.
Well, the article, once again, is titled Saving the Recovery from the Trial Lawyers. You can find it at the Washington Examiner. Its author is our friend James Copland, Senior Fellow and Director of Legal Policy at the Manhattan Institute. Jim, thanks so much for joining us on HeadLocke.
Thanks for having me, Mitch. As always, happy to be there with the John Locke Foundation.
And we hope that you will join us again soon for another edition of HeadLocke.